Nevertheless, Your Honor, you've heard all of the facts in this case, and I think the key point here in sentencing is to honor the jury's verdict. This jury found him not guilty, not only of murder, but of voluntary manslaughter. They found him not guilty on 2 different counts of voluntary manslaughter. Now the state is asking you to ignore that fact and give him the maximum. Not only do they want the maximum on aggravated assault, which is for having a gun, they want you to give him an additional 5 years for having a gun. The fact that you may be allowed to do it doesn't mean that the court should do it. But there's a huge difference that if the jury had come back guilty with voluntary manslaughter, guilty that Vincent Hardeman was responsible for her death, as just opposed to guilty on aggravated assault. To ignore that fact, if this court were to ignore that fact, you would not be honoring this hardworking jury's verdict. I think it's instrumental to the system, it's protective of constitutional rights and jury trial rights to honor the jury's verdict. Consequently, Your Honor, I'd ask you to impose...
Well, the jury could have easily found him not guilty of all the charges.
That's true, and they could have easily found him guilty of voluntary manslaughter as well. We don't know. Aggravated assault may be for something prior to Mario Hamilton encroaching on the client.
How important is it for society to be protected from violent criminals?
It's extremely important.
Okay? And I appreciate the mother's kind remarks about her son, but I wouldn't expect any mother to say otherwise. But the problem I've got is we've got a gun incident, whether or not it happened, it's on a 911 tape. Then we take the gun with us and we do this. And certainly I respect the jury's verdict. I also understand that it is my belief that your client is a dangerous, violent criminal. So I respectfully disagree with his mother. And so, you know, if the verdict is inconsistent, then we can let an appellate court tell us. But this was a senseless death. And you've done a great job for your client, a fabulous job for your client. But you didn't make the facts. Okay? I mean, it's a wonder that more people didn't get killed. You know? You never know. And, you know, it may be the right thing to say, well, the jury found him not guilty of murder. But, you know, what's the right thing when he gets out, he's got a gun somewhere else? He didn't learn from the first incident. What was it, an 8-month difference? 6-month difference?
April 27th to December 16th.
Actually, Your Honor, there was nothing prohibiting him. I mean, whether he should have a gun or not is a different question. But of course, he was not a convicted felon at the time. There was nothing prohibiting him from having a weapon. I understand the court's...
I just think he's prone to carry a gun, and he's violent, and he's dangerous. And I think it's my job to protect society from a person like this. There's 2 kinds of criminals. One we're mad at, and one we're afraid of. We've got to do the best we can with the criminals that we're mad at. But the ones we're afraid of, we got to put them in prison to protect other people. And I just see no reason to give your client any mercy. I don't.
Your Honor, I will just, again, I'll renew my request that you do not sentence him as if he had been found to be guilty or responsible for the death. I would ask you to honor the jury's verdict.
I'm going to sentence him because he shot him. That's where the jury, he shot him or he scared him with the gun. One or the other.
In that case, Your Honor, I would ask that you give him a sentence of 20 to do 7 and to suspend or probate any additional time on count 4. Count 4 is obviously the same conduct as count 3. Thank you.
Thank you. Yes, ma'am.
Your Honor, actually count 4 is to unlawfully commit an assault upon the person of Mario Hamilton by shooting him with a handgun, a deadly weapon. So even though the jury came back not guilty on felony murder and voluntary manslaughter, this charge is not for scaring him, it's not for assaulting him with the weapon, it's for shooting him with a handgun, and we would ask for the 20-year maximum.
I can't do anything but the max. It's 20 years on the aggravated assault, 5 years consecutive on the gun charge. Sir, you have a right to seek post-judgment relief from your conviction by either making a motion for a new trial in this court and/or filing an appeal to a higher appellate court. If you want to file a motion for a new trial or an appeal, then you will need to file the said motion or notice of appeal with the clerk of Superior Court of this county within 30 days. You may want to more fully discuss this with your attorney. If a motion for a new trial is made and the court denies it, you will have 30 days from the filing of this order.